Hello and welcome everyone to the third presentation in our public sector webinar series on reining in risk in government projects and procurement contracts. Before I commence, I'd like to acknowledge the traditional owners and custodians of the land on which we are, the Wajak people, and pay my respects to their elders, past, present and emerging. My name is Donna Charlesworth and I lead the public sector team at Clayton Utz in Perth. I advise on both public and private sector clients on procurement and tendering, construction and infrastructure projects. I'm pleased to be co-presenting this webinar with Eloise Hopkinson, a Senior Associate in the public sector team. Eloise and I will be taking questions during the last 10 minutes of this presentation, so you should see the moderated chat box on the bottom right-hand corner of your screen. If you've got any questions as we go through, please put your questions in the chat box and we'll try and get to them at the end of the presentation. If we don't get a chance to ask every question live at the end of the presentation, we'll endeavour to follow up. And a recording of this webinar will be sent out in the coming days. What we're going to talk about today is mitigation of risk. In a year that has been like no other year, the issue of risk in government contracting has become a critical key focus. It's under the spotlight in a way that it probably hasn't been ever before. Today what we'll be discussing is how to mitigate risks in tendering and the negotiation process, and how to negotiate certain key risk allocation clauses, being indemnities and exclusion clauses, force majeure and limitation on liability. Even pre-COVID, Western Australia was facing a huge focus on government tendering and procurement risk. There have been several fairly recent high cases involving a couple of different public sector agencies in Western Australia that led to some inquiries and some real focus and attention on what is going wrong in government procurement and the need for better risk management in contract administration. What we're seeing now on the ground as COVID-19 pandemic has arrived is that there's a compounding of those risks involved in government procurement. The factors that are compounding those risks start firstly with the increased emergency procurement and economic stimulus packages. Every government in Australia, the Commonwealth, all the states and territories have all announced their own economic stimulus packages to address the economic and social impacts of the pandemic. Just recently, the WA government announced a further $2.7 billion in economic stimulus packages, which now takes the WA government alone to, I think, $5.5 billion since the pandemic began. That obviously means there's a lot more money in the system for government to procure. Second compounding risk factor is that parallel with these significant economic stimulus packages has been directions issued by government to ease procurement requirements. Those standard procurement requirements that public sector would generally comply with have now been eased so that procurement can happen in a faster and more efficient manner. For example, the procurement practice guidelines issued by West Australian government recently reduced the monetary thresholds for procurement from local businesses. So now it allows you to issue a direct quote from a single, request a direct quote from a single supplier for procurement of a value of up to $250,000. It's a significant increase, as previously the limit threshold was $50,000. The public sector can also invite an offer to be made from a single supplier for procurements up to a value of $500,000. Again, a significant increase on the standard $250,000 threshold. Another factor in terms of compounding risk on government procurement is the speed and urgency of the emergency procurement that particularly the Health Department but other public sector agencies have had to comply with. The urgency and the imperative to try and get government funding to the market more quickly does have a couple of implications. It could potentially encourage workarounds and major departures from normal risk tolerance. It could result in regulatory compliance and due diligence and audit issues that would otherwise have been addressed being neglected. And it might also result in increased pressure on the public sector to renew existing contracts regardless of the poor performance of the incumbent supplier. We've already seen examples of these kind of pressures that the urgency of emergency procurement has had in other states in Australia. The public sector in procuring is also facing the risk of uncertainty and lack of information. It's dealing and making decisions on emerging information rather than the full range of information that it would otherwise undertake a regular procurement. The use of direct negotiations or limited tenders is also creating another layer of complexity and potential for risk. The improper use of discretion regarding the choice of supplier or contract terms favourable to the supplier can be a consequence of direct negotiations. It is potentially possible as well that we might also see agencies tempted to exploit the current relaxation of the procurement requirements to undertake non-emergency procurements with less stringent procurement frameworks. So, for example, where procurements have fallen behind schedule, it might be an opportunity potentially for public sector to enter into direct negotiations in a situation where they wouldn't otherwise have been able to. And finally, layered on top of all of these compounding factors is the fact that we're facing a construction-led recovery. Both public sector agencies and industry are already very aware or very attuned to the fact that there will be a shortage of skills and there will be supply chain bottlenecks that will cause delays in projects going out to market all at the same time. That's a real issue in terms of timing and access to the market. One of the ways that we've seen public sectors try and address that challenge of the construction-led recovery is a move to consider a more collaborative risk allocation in terms of trying to enable contractors, for example, in the construction industry, smaller contractors by way of packaging, etc., and moving that risk allocation from the traditional procurement risk allocation to something that is more collaborative. Making those kind of risk allocation changes in this environment requires some deep thought and consideration, and that's why we think it's relevant today to revisit some of those key risk allocation clauses to refresh on why they're necessary and how they might be addressed in this environment. Some practical steps to mitigate integrity risks. There's been a lot of information, I think, that has been discussed within the public sector, particularly recently through the Public Sector Commission, that have given some practical examples. Some of those are very easy to implement. Others, perhaps the cultural side, may be more difficult. It's imperative that that leadership and that integrity during government contracting is led from the top down, and that there's checks and balances at every stage through the procurement phase. I guess the key practical tip is to really consider, does it pass the pub test? If there is a feeling that even though you may be working well within the parameters of the procurement framework and guidelines, but there's something not quite right, if you think it would raise eyebrows were you to tell the story at the pub, then it probably is something that you need to discuss within the agency or with others. This kind of cultural change is obviously something that has to be at every layer of procurement, not just from contract specialists, but also from the very top of the public sector agencies. It's critical to ensure that there's no one person who's in control from the beginning to the end of the procurement process. Red flags on that kind of integrity risk can be where, for example, somebody doesn't give up control of a procurement that they're undertaking. They don't go on holidays for a long period of time. They try and maintain that kind of control and exclusive management of the procurement for the process. There's been a lot of changes in both legislative and in operational aspects of how government agencies can electronically sign documents, and it's just a critical risk mitigation factor that as an agency, as a public sector agency, you need to understand who has control of the e-signatures and what are the protocols for how they could be applied to procurement documents. It's a little difficult perhaps in this environment of moving fast to market, but it's imperative that although there is a greater increase in fast procurements, you do still need to understand and apply standard conflicts of interest and due diligence, know your counterparty, try and avoid engaging if your counterparty is a member of the public sector with commercial business interests that might create again, concerns that it's not going to pass the pub test. There's been a lot of comments from contractors that even if they are on government panels, it can sometimes just be used as a stalking horse, and that procurements may not be distributed in a fair manner, but it becomes particularly important if new procurement activities are being undertaken by parties or suppliers that aren't on a pre-registered, pre-qualified register or a government panel. You need to undertake the due diligence as to who you're actually dealing with. A reminder to check the lists of debarred or suspended suppliers to make sure that even though there is the potential for those suppliers to obtain the benefits of the relaxed procurement guidelines. And finally, I think at this time more than ever, it's imperative to seek procurement legal or probity advice if there is any concern. The sense and the rush and the pressure on public sector employees at the moment means that it's more important than ever to have these conversations, even if it's just a sanity check or a double check as to whether the procurement risks have actually been appropriately addressed. I'd like to turn now to the first of the three risk allocation clauses that we're going to speak about today, and that is indemnity clauses. When we think about collaborative contracting, and if as an agency you're considering moving the risk allocation of your agency to something that's a little less traditional, that is not putting all of the risk on the contractor or supplier, This will be one of those clauses that you'll need to look at with fresh eyes. And, you know, as lawyers, we would say, you always need to read the indemnity clause, not just skim over it as boilerplate, but actually try and understand how the indemnity works. It is essential that you read each of these clauses, the indemnity clause, the exclusion clause, the FM clause, and the cap on liability clause, together with the insurance clause that I'm going to deal with today as a whole, because they are all very interrelated under the contract, and it's not possible actually to really understand the implications of the risk allocation without looking at the whole picture. So an indemnity clause is a primary and independent promise to hold somebody harmless or to make good loss suffered by another party. It's an interesting form of risk allocation because it actually moves standard position under the common law, whereby a party wouldn't necessarily be responsible for that party to say, I will hold you harmless in that position. An example of an indemnity clause can be seen in the Australian Standard 4902, whereby the contractor in a construction contract provides that they'll indemnify the principal against loss or damage to the principal's property, against claims for personal injury or death or damage to any other property arising out of the contractor performing the work. But that indemnity is reduced to the proportion that the principal has actually contributed to the loss. So there is a reduction in the extent of the indemnity in the 4902. You also see other kinds of indemnity where, for example, the contractor will indemnify the principal against breach of intellectual property rights, or even against damage to third parties. So these are the kinds of categories that the public sector would generally be looking for the indemnity to cover off on. The reason why it's a standard provision in government contracting that government requires the private sector or the contractor or the supplier to provide an indemnity is there are multiple benefits, basically. There's no concept, unlike in common law, where you suffer damage and you need to prove the loss, there's no concept under an indemnity clause of remoteness of damage. Provided the indemnity covers the category of loss that you're trying to seek cover for, that remoteness of damage is covered. Another advantage is that there's no obligation to mitigate loss. Again, this is unlike the position of common law where the person who has suffered the loss does have an obligation to mitigate. In the case of an indemnity clause, there is no obligation to mitigate. This is because proceeding or litigation on an indemnity would be a breach of the contractor to provide the indemnity. It wouldn't be the event giving rise to the claim under the indemnity. So duty to mitigate doesn't arise as opposed to the common law position. It also provides the opportunity for government potentially to extend the limitation period. This is again because in the context of an indemnity clause, government would be calling on the contractor in terms of a failure to comply with the indemnity, rather than which might happen long after the event of loss occurs. Under the common law position, the limitation of liability period would be triggered from the date of the loss, whereas if there's a breach of an indemnity clause, it would be triggered much later than that. So there is the potential for a longer period of coverage. Indemnities also allow a party to bring substantial claims for ongoing losses. as opposed to the common law position where the injured party only has one opportunity to recover those losses. And finally, the amount recoverable under an indemnity is different too, and quite typically greater than damages for breach of contract. For these reasons, it's well worthwhile considering where your government agency's current indemnity clauses lie, and be very conscious of the fact that if you are going to consider changing risk allocation in the context of the pandemic and the need to procure quickly, whether you actually do intentionally want to relax any of these advantages. Let's talk now about an exclusion clause. Exclusion clause is exactly the opposite of an indemnity, where an indemnity, under an indemnity, a person is saying, I will take on responsibility for all of this loss. An exclusion clause is where a party says expressly, I am not going to be responsible for that loss, where I would otherwise have been under the contract or at common law. So exclusion clauses reduce the liability of the benefiting party. You often see these in government contracts and in private sector contracts where there's an exclusion of the consequential loss. Generally, this is a mutual exclusion where both parties say neither of us will be responsible for consequential loss that we can't ascertain. So that's an exclusion. A very, very important point to make about the interpretation and how the courts approach exclusion and indemnity clauses. The courts are unanimous and have considered this on many occasions, and the principle is that they will be construed strictly. If there's any doubt or any ambiguity, that doubt will be resolved in favour of the indemnifier, but the court will not rewrite the provision. A really interesting case last year, in the case of Thistle, is a good example of how the courts will approach indemnity and exclusion clauses. Well, in this case, in the case of Thistle, it was an exclusion clause the court was looking at. A service station had engaged a supplier to, a service provider to come and do maintenance services on the service station. The contract contained an exclusion clause that excluded the contractor or discharged the contractor from all liability in respect of the services, whether in contract, tort, or otherwise. That exclusion clause was, the owner argued, or the principal argued, that because the service provider failed to undertake the construction of the platform in accordance with the design, and therefore it had failed to provide the services, meant that the exclusion clause did not apply. The court did not agree. They rejected this argument and said, no, that's not right. Actually, the exclusion in Thistle's liability is clearly in respect of the services that had been contracted. So the ultimate result was that one exclusion clause removed all liability for the contractor for their failure to comply with the design. That decision upholds a long line of cases that exclusion clauses are to be read with their ordinary meaning in the context of contract and not subject to any special limitations. While we're on exclusion clauses, another point that I'd like to make is in relation to the design issue that a lot of procurement contracts will address. We're now seeing a real tendency for indemnities to be covered in the design obligations by way, for example, we've seen it in the latest edition of the FIDIC Silver Book, Engineering Procurement Construction Contract. The contractor's design liabilities are now linked to the fitness of purpose warranty to an indemnity. So you've got an indemnity saying contractor indemnifies, it will comply with fitness for purpose and design obligations. And the contractor will wear the breach clothes. That, however, itself is subject to an exclusion of liability clause. So there are certain carve-outs, and that's where you need to read both the indemnity and the exclusion clauses very carefully together. So some drafting tips for exclusions and indemnities. Don't treat them as a boilerplate. They really require careful attention, and be very careful. Any minor any change that you might consider minor may actually have a very significant consequence. So really treat it very carefully, and if in doubt, seek advice. Consider whether the indemnifier can actually meet the indemnity. An indemnity is only of any value to government if it can be called on, and if the party, the counterparty, can actually answer its obligations under the indemnity. It's absolutely useless if your counterparty is going to go insolvent and they're not covered by the insurance to cover the indemnity. So you need to check the insurance's situation. If it's the government agency that's providing the indemnity, you'll definitely need to consider the risk cover issues, which the risk cover situation is generally that if you, as an agency, go out and contract and bring in a greater liability than the government agency would normally have had it at common law, then you may be subject to excluding the ability of the agency to be covered by the risk cover insurance. Think very carefully about the width of the indemnity, and this comes into an analysis of where the risk allocation will fall and how you want to approach that. If you want to push everything onto your contractor or supplier, you would want the wording of the indemnity to be very broad. Use words such as loss arising out of or in connection with, and refer to any act or omission. If, on the other hand, you're taking a more limited or narrow collaborative approach to risk sharing, you may want to consider narrowing that wording to agree that the contractor is only to indemnify you for situations where the loss is directly caused by, and limit it to negligent acts. Again, think very carefully about what the consequences of that limited wording will be, because unless the government agency is then put to the burden of establishing that the loss is directly caused by that act, it will cause difficulties down the track. However, as I previously mentioned, these are the kinds of considerations that government is thinking about at the moment in terms of trying to put out to market a risk allocation that can actually be tolerated by contractors in the current economic situation. As a key principle, don't agree to indemnify for another's conduct, primarily because you've got absolutely no control over it. And that's why, as government agencies, government's generally not indemnifying the contractors. You're getting the contractors to indemnify. What you'll find then in the negotiation is that contractors will say, you've asked me to indemnify you for breach of IP, but I've got suppliers, original equipment manufacturers, etc., supplying to me, and I have no control over their IP issues. So it will require you to consider actually if you're not in a position to indemnify for another's conduct, how then do you address requiring someone else to indemnify, requiring your contractor to give you an indemnity for things that they have no control over? The indemnity should also include, if the party who is giving the indemnity should also include carve-outs for losses contributed to by the other parties. So, for example, if the government causes the loss to be increased, that would need to be expressly carved out of the indemnity, and also losses covered by insurance. So you need, as I said, to include the relationship between the indemnity clause and the insurance clause. It's also really a very prudent thing to ensure that you've got the consent of the insurer to confirm that the policies do actually cover the kind of loss that you think you're actually getting the indemnity for. Also, bear in mind, insurance always follows the liability. It is, however, possible to impose a cap on liability, which Eloise is going to talk about shortly, where you can cap the liability to the amount recoverable under insurance. There's clearly zero point in having a contract to give you $10 million in public indemnity insurance, professional indemnity insurance, and then cap its liability to $2 million for all loss suffered under the contract. The insurer in that situation will never pay more than $2 million because insurance follows the risk. You have to establish the liability first before the insurer will pay out. In effect, you need to make sure that where you are excluding or capping those indemnities, you're keeping it to the amount recoverable under the insurance rather than recovered. I'm going to hand over now to Eloise to talk about another contract risk allocation clause that we often see, which is force majeure.
Thanks, Donna. Right, so today I'm going to talk a little bit about force majeure clauses and how they operate, particularly in the context of COVID-19. And I can say from Donna and my own experience that we've had a lot of questions about how the pandemic fits into existing force majeure clauses, and also how to manage that risk in force majeure clauses moving forwards. So we'll start a little bit with the basics. What is force majeure? It's a contractual principle that acts as an alternative to the discharge of a contract by frustration. So frustration has a much more limited scope because for it to apply, performance of the contract needs to be radically different from what was intended by the parties. So to overcome this sort of limited doctrine of frustration, force majeure may operate. The force majeure is a contractual principle that is generally defined as an unforeseeable, unavoidable external event that is beyond the control of the affected party and of such a nature that it could not have been avoided or overcome by that affected party. Generally, we see that when a force majeure clause is relied upon by a party, depending on how the contract is drafted, it will entitle the party to an extension of time claim and sometimes delay costs. This is in direct comparison with the doctrine of frustration, which, as well as not being limited, which is limited, it's fairly extreme in its application. Frustration can lead to termination of the contract. So in terms of force majeure, obviously the effect of the force majeure clause is going to depend on the precise drafting of the contract. There's no common law definition of force majeure, but courts have provided a lot of commentary on what does and what doesn't constitute a force majeure event, which certainly assists government principles in understanding the limitations of force majeure clauses. So the case on the slide, Matsoukas and Priestman, is the earliest English case to consider the meaning of force majeure as a standalone term, and that confirmed that the court didn't want to give any definition to the words, but stated it should be more expansive than simply an act of God. And an act of God was the traditional force majeure clause. That was sort of what force majeure clauses were intended to deal with, or events in nature. So Matsoukas and Priestman The court held that force majeure covered the dislocation of business owing to a universal coal strike and access to machinery, but it didn't cover bad weather, football matches, or a funeral. So more recently, force majeure clauses have been drafted to cover a wide range of circumstances that might impact the commercial interests of the parties, so acts of war, terrorism, strikes, government action, and pandemics. So it's worth noting as well, before I go to the next slide, that the party seeking to rely on the force majeure clause has the onus of proof. So force majeure and COVID-19 goes without saying that with the continuing presence of COVID-19 in our lives, businesses are likely to continue to be exposed to a heightened risk of legal implications arising across supply chains and a mounting economic cost. And we can all agree that there's been a global disruption to business as usual. But what the practical effect of this might be is that parties to a contract who are in distress may seek to delay or avoid performance of their contractual obligations through the use of contractual mechanisms such as force majeure or frustration. And for this reason, at the beginning of the pandemic, one of the key issues we were asked to advise clients on was the operation of these force majeure clauses, and also, as I mentioned earlier, the incorporation of more specific force majeure clauses going forwards. In terms of COVID-19 and force majeure, there's clearly very little case law at the present time. It's all very new, but when looking at putting together this presentation, we did find a 2003 SARS epidemic-related case, which is Li Qingming and Zhuan Yixiong, which related to frustration. The Hong Kong case certainly demonstrates that counterparties are going to seek to frustrate contracts or possibly seek delay costs through the operation of force majeure clauses by attempting to fit the circumstances of the pandemic into clauses in the contract. So in this case, the Hong Kong court actually rejected a tenant's claim that a tenancy agreement was frustrated because the premises were affected by an isolation order. So the isolation order was issued by the Hong Kong Department of Health by reason of the SARS outbreak. And the practical effect in the tenant's case was that it wasn't able to inhabit the premises for a period of 10 days. So interestingly, in this case, the court held that the 10-day period was insignificant in the view of the 2-year lease duration. And while SARS was arguably a foreseeable event, it didn't significantly change the nature of the outstanding contractual obligations to the parties in the case. So obviously the force majeure wasn't an issue here, and this Hong Kong case related to frustration, but I certainly think that in the right contractual circumstances, parties will try and use the COVID or a pandemic situation to mount a force majeure claim against the principal in a very similar way to this. And as we mentioned previously, given the limited scope of frustration, force majeure certainly seems like a better bet. But obviously this is all going to depend on whether COVID constitutes a force majeure event. When you're looking at an existing contract anyway, it's certainly going to depend on the precise drafting of the clause. So typically in a force majeure clause, you're going to see a list of events which is setting out what does and sometimes what doesn't constitute a force majeure event for the purpose of satisfying the clause. Where the force majeure clause sets out a list of events, it might very well include a pandemic. So this will typically be done by reference to a classification by the World Health Organization. Obviously, COVID-19 has been classified by a pandemic as a pandemic for quite a while. So those clauses are obviously designed to catch another pandemic if it were to arise. Other common categories of force majeure event that could be triggered by the COVID-19 crisis might include changes in law or regulation, acts of governmental authorities, That could include maybe lockdown laws or possible curfews, although those things haven't been tested yet. Restriction or suspension of licences, delays or in transportation or communications. And in any event, typically what we see is there's a wrap-up provision for events that are beyond a party's control, and the COVID-19 pandemic could certainly trigger that clause, even if it's not covered by the specific categories listed. So for contracts that have already been executed, do check the wording of the clause and see how COVID might fit in. It's also a good idea to look at what the contractual implications and contractual remedies of a force majeure event existing might be. So usually in our experience in design and construction contracts, you might see that in the event that a force majeure event has been held to have occurred, an extension of time is often a remedy, and sometimes delay costs, but it's certainly going to depend on the wording of the contract. But it's something to be aware of in the current circumstances if you're concerned about distressed contractors, distressed suppliers, those sorts of things. So food for thought. More forwards looking, for contracts that are still in a tender or negotiation phase, it's maybe useful to consider whether a force majeure clause could include events that existed at the time the contract was entered into. So do these events constitute circumstances beyond the control of the party, given that they were actually known at the time that the contract was executed or negotiated? So applying this to COVID-19, given it's now known, if one was to enter into a contract during the pandemic, could COVID-19 actually constitute circumstances beyond the party's control? It's an interesting question, I think. Or could they now, like, because, you know, they're now controlled, we know about them, would this count? So the case of Reed and Smith Line and Ministry of Agriculture, Fisheries and Food held that there was no settled rule of construction that prevents a party to a force majeure clause from relying on events in existence at the time the contract was entered into as an event beyond the party's control. So foreseeably, depending on the drafting of the contract, so provided that COVID-19 fit into a force majeure event category, there's nothing to say that although it's now possibly known risk, parties can rely on it as a force majeure clause moving forwards. So consider that when you're drafting your force majeure clauses. On that basis, a few tips for drafting FM clauses. Use precise and unambiguous language because, as Donna mentioned earlier, in contract construction, words will be given their ordinary meaning. Consider all of your industry-specific risks, so be as specific as possible. It's not necessarily a good idea to rely on catch-all terms if you're trying to capture something in a force majeure clause. If catch-all terms are included, consider the effect of those terms and how they're treated in the case law. They might be narrower or broader than you think, so it's certainly something to consider. So for that reason, if parties have decided to include a COVID-19 or a pandemic term into their force majeure clause, try and be as specific as possible. So as I said previously, it might be useful to link the concept of the pandemic to the directives given by the WHO, because that'll obviously capture COVID, and it might capture, God help us all, if there's another pandemic in the future. If you do decide to include COVID as a force majeure event, with reference to the risk profile of the particular contract, consider what the contractual remedies and implications of that force majeure event will have. So, as Donna mentioned, read the contract as a whole. Are you going to entitle the contractor to have an entitlement to time, costs, or both, or even something more extreme? We haven't seen the contractual implications of COVID-19 and force majeure in this remedy sense addressed in any singular way. So there hasn't been a whole of government approach to this. So For example, some government principles we've seen have allowed for an extension of time when factoring in COVID-19 into new contracts. On the other hand, some have actually allowed for delay costs as well. So that will be included into the extension of time clauses. On the other hand, we've actually seen some constrain their definitions of force majeure to be so narrow that force majeure actually doesn't cover a pandemic or COVID-19. So when considering the contractor's rights under the contract, there's no correct or incorrect approach, we think. The decision should be made with consideration of the risk profile of the contract, of the project, so how large it is, the principal's budget, the contractor side risk. So those sorts of things should be considered prior to making any decision. Finally, the force majeure event, as defined, can be exclusive or inclusive or both. So make it clear when you don't want force majeure to apply events. So if you are a principal, you might not actually want COVID-19 to apply or to be included as a force majeure event. So a starting point might actually be to expressly exclude it. A few other little drafting tips: consider your notice and timeframe requirements, and if applicable, in the case of certain consumer contracts, although this is not necessarily something for government clients to think about, but consider whether a broad force majeure provision might actually be an unfair contract term under the Australian consumer law. So, liquidated damages. I'm just going to spend a little bit of time talking about limitations of liability in the context of liquidated damages clauses. So at the heart of commercial contracting is this concept of time, and liquidated damages obviously arises from that. In terms of what liquidated damages are, it's maybe easier to talk about what they are not, and they're an entirely different beast from general law damages. Obviously, the purpose of general law damages is to compensate the innocent party for a breach of contract, but the entitlement to general law damages depends on three limbs. That is proving breach of contract, establishing that the loss and damage has resulted from the breach, and proving the quantum of its loss and damage. Whereas liquidated damages, the effect is to form a contractual agreement between the parties about the remedies that will be available to the principal if completion is delayed or supply is delayed, depending on what the purpose of the contract is. And in this case, to distinguish it from general law damages, you only need to establish breach as one of those limbs. And that's obviously a huge benefit. For government principals as well, it has many other benefits. It's the certainty of knowing that you're protected in the event of a contractor's breach. It often avoids or simplifies disputes. It provides leverage in complex, multifaceted disputes. Parties are also better able to price exposure to liquidated damages and therefore offer better value for money to principals, especially where liquidated damages are capped. Contractors know exactly what they're getting themselves in for, and I think that is very helpful. That's very helpful. They're extremely useful in circumstances where loss is non-monetary and thus very difficult to prove and quantify, again, sort of distinguishing it from this concept of general law damages. And they do act as an incentive for contractors to perform their obligations under the contract with time. However, parties cannot agree to penal provisions in the contract, so you can't have an absolutely enormous liquidated damages amount unless it's justified. So the primary grounds for challenging enforceability of liquidated damages is that they're a penalty. So it's crucial to consider whether your liquidated damages clauses will be allowed to stand on that basis. We see liquidated damages being challenged on the grounds of penalty in construction contracts, maintenance contracts and supply contracts more often than you think, especially, even when those clauses have long been agreed to and the contract has long been executed. When circumstances change, such as in the current environment, distressed parties are going to look for a way to challenge obligations under this contracts, and that can include challenging liquidated damages on the basis of penalty. Out of interest, there are a few other grounds for challenging liquidated damages clauses. That's going to depend on the drafting of the event, and they're not as common, but just out of interest, they include maybe that the liquidated damages clause doesn't apply to the particular event, a condition precedent hasn't been satisfied, or the clause is void for uncertainty. But we think that the primary issue to be aware of when considering whether your liquidated damages clause passes the test is whether penalty. So Dunlop Pneumatic Tyre Company and New Garage Test provides the leading English authority on liquidated damages. This developed a few tests which are listed on the slide. Is the sum a genuine pre-estimate of damage? Is the sum extravagant and unconscionable amount in comparison with the greatest loss that could be proved? Is the sum payable on the occurrence of one or more or all of several events of varying seriousness? These concepts have been confirmed by the High Court of Australia, although somewhat refined. There's a general requirement that in order to be ruled a penalty, liquidated damages must be shown to be out of all proportion to the damage likely to be suffered or are extravagant and unconscionable an amount. And this has been confirmed by the High Court in Ringroad Proprietary Limited and BP Proprietary Limited, and more recently a 2016 case, ACIOCCO versus an Australia and New Zealand banking group. So just to briefly take you through the ACIOCCO case. This case concerned the enforceability of late payment fee provisions in contracts between the appellant, ACIOCCO, and the respondent in relation to late credit card accounts. ACIOCCO was charged with 26 late fees and alleged, amongst other things, that those fees were unenforceable as penalties. The High Court held that the late fees were not penalties, although unhelpfully gave almost all separate judgments. So there's a lot to process. But crucially, it included the confirmation that a genuine pre-estimate assessment of maximum conceivable loss is done ex ante, i.e. on forecasts, rather than taking into account actual loss. It indicated that the tests in Dunlop are guidance and shouldn't be literally applied. It adopted and expanded this concept of a legitimate interest test from Cavendish, another case, where the true test is whether the provision is a secondary obligation which imposes a detriment on the party in breach out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. So what does that actually mean? In summary, I would say liquidated damages are only enforceable if they're out of all proportion to the damage likely to be suffered. Courts are generally unwilling to open up parties' apparent agreement as to the liquidated damages figures, so bear that in mind. So long as the parties can show a genuine and not necessarily accurate pre-estimate of the loss anticipated to be suffered in the relevant circumstances, this will usually suffice. However, I would say that calculating liquidated damage accurately as possible based on forecasts is recommended. You're going to try and avoid the penalty argument that contractors can bring down, and also it just makes it more accurate for you moving forwards. So calculating liquidated damages, I thought this point at the top was fairly interesting, so I've incorporated it into the slide. We've already established that LDs can't be a penalty or they're going to be unenforceable. But on the other end of the scale, courts will actually override a general law entitlement to damages where liquidated damages are included and general law damages are excluded, even if those liquidated damages are extremely low. It's not something that happens often, but there's certainly an appetite for it in Australian cases. This was demonstrated in the One Tree case, New South Wales case in 2018, where $1 liquidated damages was held to override an entitlement to general law damages. So for that reason, unless there's minimal risk to you as a government principal, a symbolic liquidated damages amount is not advisable. So when considering your liquidated damages amount, we recommend that you take into account some of the following: your direct costs, any loss of revenue that you may incur from late delivery, as well as capital and public utility, the diversion of resources that might result from late delivery, maintenance costs. So those sorts of things should be strongly considered before arbitrarily attributing a number to a liquidated damages clause. Some other practical considerations to consider when calculating and drafting liquidated damages clauses. Calculate with respect to known loss where possible. Maintaining current capabilities, including support and upgrade, should be considered. Cost of resulting loss of capability compared to new capabilities. The costs of engaging external providers like legal. Obsolescence costs, so the costs of labour and materials consumed in producing the deliverable. We also think it might be a good idea to keep records of any calculations or considerations, because if it is tested as a penalty, these sorts of considerations will be very, very useful. Include statements that loss may be complex, difficult and expensive to calculate, because again, this might assist if the penalty is tested, if the LD is tested as a penalty. And don't specify the same amount for trivial breaches in the contract. So it looks like you've really thought about it. This goes to the notion that the forecast is a genuine pre-estimate. And finally, drafting the damages clauses. A few things to consider here. Ensure that your contract makes it very clear when liquidated damages are payable. For example, will they be payable past a certain milestone? For example, in a construction contract, past the date for practical completion, or maybe delivery or supply of the product, depending on what the contract is. Ensure that the amount of liquidated damages is clear, both in accordance with the amount calculated and also how prescriptive the liquidated damages are. So, for example, have you got a daily or weekly sum, which would be more preferable? Consider the circumstances of the contract and the nature of the project when you decide, and be sure to list it in the contract particulars. To avoid the prevention principle undermining rights to liquidated damages, check if there's an extension of time clause in the contract which would give the contractor a right to time relief for principal cause delay, and also an extension clause which would authorise the superintendent to apportion between principal cause delay and delays for which the contractor is possible. I think also very importantly, as I previously discussed with the One Tree case, certainly preserve the right to claim general law damages. Will always help. Okay, so that concludes our presentation for today. I'm just going to hand over to Donna now to address any of the questions that we've received, or feel free to input some questions into the moderator chat if you do have any.
Thanks, Eloise, that's great. Before we address questions we've received, I just want to let everyone know that if you do have any agency-specific questions or feedback relating to your organisation, then don't hesitate to contact us directly. Given the limited time, I'll start by addressing questions sent through in advance. We've got the following question on force majeure, which I'll invite Eloise to answer. Where this question relates to what's the usual or what's the most common relief in terms of force majeure in COVID situations that we've been seeing?
In terms of what we've been seeing moving forwards, well, traditionally I think we've been, in our review of existing contracts, the most common thing that we've seen is just an extension of time. I think that that will probably be the case moving forward, certainly from our end acting for government principles. So I would say just an extension of time, but as I mentioned during the presentation, there's no one-size-fits-all answer, and it's definitely going to depend completely on the risk profile of the actual contract itself. So you might find that you, as a government principal, are in a position to award delay costs if that assists during the negotiation period. And I don't think that's necessarily an incorrect position to take.
I think that's right. And we've seen a range of different things. For example, Department of Defence does permit cost relief during force majeure, but we're not seeing that as that's really quite an unusual risk allocation mechanism. Look, I'm conscious of time, so if you do have other questions, please send them through. But I think that concludes our presentation today. Thank you very much for joining us online. I hope the information was practical and that you've got a greater understanding of the risk allocation mechanisms and dealing with risk in the tendering and negotiation phases as well, particularly during COVID-19. We'd love to hear your feedback on today's session. We'll be sending around a survey after the webinar in the next few days. It's also a great way, if you can participate in that survey, to contribute to the next conversation. We will be holding our Government CLE Day in November and really look forward to seeing you then. But if you do have particular topics that you'd like us to address, that's a good opportunity to shape that conversation. Thanks again, everybody, and see you next time. Thank you.